Good afternoon. Welcome to EduSet Network. Friend, as you are aware, this week we have organized series of lectures on Constitution of India, and in last three lectures we tried to understand the framing of Constitution and various sources from where we have taken the different provision and included in our Constitution, and then we talked about the fundamental rights and directive principle. But most of the question which you were asking is related to law and politics. There is some relation between law and politics. So in today's lecture, we will try to understand the relation between law and politics. And for discussion on this very topic, we have in studio Dr. Aparajita Kashyap. She teaches international law and international law in University School of Law and Legal Studies in Guru Gobind Singh University, and her area of specialization is law and international relations. So on her behalf, I welcome her for EduSet lecture. Over to you, ma'am.
A very good afternoon. Today's lecture is devoted to the relationship between law and politics. I'm going to look at how law affects or regulates politics and how politics also then gets involved in formulation of laws. So I begin with giving a bit of a background about how law and politics, they complement each other or they contradict each other. Now, democratic societies, when we see, why we call a society democratic is because they are organized societies. And the formulation of laws in democratic societies does not only depend on the government or the ruling class, it is the citizen who is also involved in the process of lawmaking. Now, every democratic society has expected norms of behavior. And how do we ensure those norms of behavior? It is through the formulation of laws, and any deviation from these expected norms of behavior then are punished under the law. Now, any democratic setup has a limited government. What we mean by a limited government is a government which is not autocratic or authoritarian, but it has certain limitations. The limitations that if it does not perform, it has the right to be overthrown. This was the basic conception which started with the theory of social contract, which were given by Hobbes, Locke and Rousseau. Hobbes did not, he talks about a relationship where people did not have the power to overthrow the ruler. But with the coming of Locke and Rousseau's contract theory, they said that people had the power to overthrow if the ruler or the law was not meeting their expectations. Another thing about a democratic society is that they adhere to the rule of law. Now, adherence to the rule of law is one of the most important criteria for any democratic society. And what is rule of law, we will see in the later slides. Now, one important aspect of a democracy is that, see, every country has a constitution of a sort. Even if it is an authoritarian government or, for example, governments like Nazis and fascist governments, they also had a kind of a constitution. Although those constitutions were rather not based on consensus, Hitler and Mussolini, for example, would rule by decree. Therefore, the constitution did exist, but it was a farcical constitution. So just having a constitution is not enough. Then we have a concept called constitutionalism in democracy. And according to Carl Friedrich, he defines it as the commitment on part of the political community to be governed by the constitution. I may have a constitution, but I am not willing to abide by the constitution or follow that constitution. So we had a lot of examples in the world in which constitution does exist, but the commitment of the government to go abide by that constitution is lacking. Therefore, having a constitution and constitutionalism are two different things. So this is basically what are the background of a democratic society. Now, coming to the rule of law, most of the countries, most of the democratic societies, they adhere to the rule of law, which means there is definite punishment for breach of law, You know that if you're going to break a law, there is going to be a definite punishment. Certainty of punishment when law is broken. If I have defied a law, there is certainty that I would be punished. I cannot get away with violation of laws. Then equality before the law. Every citizen of the country is open and has to be tried by the same law. And the most important aspect of rule of law is that there has to be an independent judiciary, free from any interference from the legislature or the executive, so that it can adjudicate without any fear of favor or punishment. So this is rule of law. Now, if we look at the role of state in lawmaking, this is the first part of the lecture in which I am trying to analyze how state affects the procedure of lawmaking. Now, let us just go back to the social contract theory. And social contract theory began with the state of nature, which was unorganized, chaotic, man was brutal, nasty, short, and they realized that every man was after the life of the other man. Therefore, the right of life, liberty, and property were being impinged upon. So they identify one person who they think that that person is capable of bringing about some order, because he either has some economic power or he has some authority. And by the very fact of him being a little superior in terms of wisdom or authority, that people go to him and they say that he must protect their right to life, liberty, and property, and in return they would oblige by obeying that king. So this was the first kind of contract that begins, and this is one of the theories of origin of state. So the origin of state is due to a contract which is signed by the people and the citizens and the ruler. But the problem with Hobbes' theory of contract was that it was a one-way contract. The king was not bound by the terms and conditions of the contract. Therefore, this kind of a contract did not appeal to many people. So then we had Locke. Locke talks about two kinds of contracts. One is the contract between people to people, and the other is the second level of contract. It is between the people and the government. And this is a two-way contract. So people feel empowered, because if the people had the right to revolt. They could overthrow the government if they were not performing. So the people felt empowered that because it is a two-way contract, I will not be dominated or subordinated. Therefore, this holds true. The origin of state, as we clearly see now, is a contract. And what is a contract? Contract is a kind of a law. So the genesis, the very genesis of a state is because of a contract. Now, second important aspect is that how do we formulate laws? How do we say that we need a particular law? For example, if we want to limit reservation or we want to create reservation, how do we fathom or how do we judge that we need a law? This kind of a judgment comes from data which the political scientists gather. So these compiled data then become inputs for the lawmakers or the legislators. Second important thing that the political scientists do, that they accumulate the public opinion, and based on public opinion then we have formulation of laws. For example, the anti-corruption movement, and there was a lot of public opinion generated that we must have some bill or some law to curb corruption. And this is why we have debates in Parliament over formulation of an anti-corruption bill. Now, the other thing is that I and you can't make a law. Just because I have some authority or some power in my place of work, I cannot form laws. That is, a law is sanctioned or valid only because it is made by the state. Therefore, the validity for the law comes only if it is backed by the state. So this point becomes very important. Then the state is also instrumental in institutionalization of the procedure of lawmaking. How are laws made? It is clearly written. The politics determines what laws to make, how laws are to be made, how committees are to be formulated, which political party members should be members of that committee. All these procedure is institutionalized some way or the other by politics. Then if we talk about the state, most of the lawmaking is devoted to either to individual rights or group rights and minority rights, because as we know in democracy, there is a fear always that the majority will dominate the minority. So to empower the minority, we need to give them some special rights. So the state ensures that individual, group and minority rights are protected in the process of lawmaking. And rulers are the ones who serve justice, because if we don't have a just ruler, then there is no justice in the state. Therefore, it is the ruler who dispenses justice in a society. Further taking this argument on role of state in lawmaking, we realize that the law becomes an integral part of a wider context, and the political and moral environment determine the statutes, the judgments and other legal production that takes place. Therefore, there are certain custom-based laws, there are certain laws based on morality. All these determine what kind of a law the state is going to have. Then the statute, the judgments, all these are guided by political factors more than anything else. Now supposing, let's just take the example of creation of Telangana. Now Telangana is created because the UPA government wanted it. So it was a kind of a political decision, because of the fact that legislations are carried out in parliament and the UPA has a majority in parliament, the likelihood of this bill getting passed is very high. So many of the legislations, many of the decisions that come are based on political inputs and political considerations. So much so that it is said that law is a creature of politics. So law is a small bit of politics. But of course we know that how then law regulates politics also. We will come in the later part of the presentation. In any state there are two levels of law. And one is the constitutional law, which is the supreme law of the land, and others are ordinary law. Now ordinary laws are ordinary because the process of changing these laws or process of passing these laws are simpler. You just need a simple majority. But constitutional laws are at higher pedestal than ordinary laws, and these constitutional laws need special procedure for amendment, special procedure for initiation, and they are placed then in the constitution, which is very difficult to be touched or tampered with. Now if we talk about the role of the state, then we have to know that the effectiveness is a necessary condition for law, because a law may be there. We know that for example, India's problem is multiplicity of laws, but enforcement is a problem. So unless a law is enforced, it doesn't become effective. It is a redundant law. Therefore, effectiveness of a law depends more often than not on what is the motivation or political will of the nation state. Now I say that effectiveness is a necessary condition for law, and effectiveness depends then on a stable political order. Also, it depends on the will and the commitment of the political party or authority. Now, so far what we have looked at is how states get involved in the process of lawmaking. Now, looking at the role of law in politics, it is very interesting to note that the very origin of state came because of the social contract theory. And what is the social contract theory? There are two kinds of contract. One is a social contract, which is people to people, and the other is a governmental contract between the people and the government, and both the parties are bound by the terms of the contract. So the uncivilized, unorganized state of nature, by the fact of the social contract theory, becomes a kind of an organized and civilized society. And the civilized society then has further creation of laws, the basic laws that we started with, because of the complexities that increase in modern industrial society or scientific society. Therefore, what we do is we form more and more laws which are more pertinent to the prevailing conditions, and in this the politics plays a very important role. But we have to look at the other side of the debate. That is, how does law get involved in politics? So whenever politicians are trying to create laws, there is certain parameter or procedural framework which the constitution has placed, and the politicians or the political parties, they cannot transgress those frameworks or parameters. Now, state and society, for example, state is a organized society. State is, whenever a society gets organized, we have the creation of a state. And state and society, how the society became a state and how the organization came about is through a mediator, and this mediator is the law. Not only this, once the state comes into existence, we have the formulation of a constitution. A constitution gets formulated, and forming a constitution is an extensive exercise. At times we have special bodies nominated for formulation of the constitution. This is called the Constituent Assembly. They deliberate, they come together, and on a particular date they then give a constitution. The constitution is then said to be enacted and adopted. But there are other countries like United Kingdom which does not have an enacted constitution. What they have done is they have compiled the Bill of Rights, the Magna Carta, the Acts of Parliaments of 1911, and all these together have then been compiled as a document which they call the Constitution. But irrespective of whatever be the form of constitution, whether it is a written constitution or an unwritten constitution, whether it is a rigid constitution or a flexible constitution, the underlying criteria is that the interpretation of constitution is very essential. And this interpretation is not left to the politicians. This interpretation is left to the lawyers, because they are the ones who are competent in interpreting the constitution. Like, there are certain clauses which have to be made relevant by reading them in a particular manner, and all of us are laymen, we don't have the competence, so we need the help of lawyers to interpret the constitution. The other example is that there are certain clauses of the constitution which are ambiguous. Now this ambiguity has to be simplified, and we as laymen cannot do that, so we need the help of lawyers. So lawyers, then they try to remove the ambiguity of the clauses of the constitution. Another aspect of law which is handy in our day-to-day political activity is administrative law. Now, administrative law is that part of law which organizes bureaucratic activity. The administrative machinery is given guidelines, and it is coordinated, the business is conducted in accordance with administrative law. Therefore, we see that this bureaucracy, which is part of the permanent executive of the executive, and executive is an organ of the government, and government is an agency of the state, and this political permanent executive is guided by the administrative law. Therefore, we see that even in the bureaucratic administration or day-to-day administration of the country, the law, and specifically the administrative law, has a lot of role to play. Then law, what is law? Law is the institutionalized form of politics. Therefore, if we say that politics is different from law, it cannot be, because law, whatever law that we have, it is guided by politics, and law also determines the path that politics is going to take. So institutionalizing the political factors and the political developments in a country leads to the emergence of laws. Now, further taking the role of law in politics, the law establishes rules of behavior in society. What is a norm of behavior? Because if we have a civilized society, everybody has certain duties and rights. So we cannot claim rights without duties, because then that becomes anarchy. And if we cannot only do duties without rights, because that leads to slavery. Therefore, there are certain rules of behavior in a society, that if you stay in a society, you have to respect the rights of the others. It is your duty to do certain things. It is your duty, for example, to pay taxes, to preserve the national monument. It is your duty to protect the right of the other people. these are the rules of accepted norms of behavior in a society. And who establishes them? It is the law, because there has to be an agency which has to regulate society. And as I told you earlier, this mediator is law. Then law also represses antisocial behavior. Now, antisocial behavior is any behavior which does not fall in line with what are the accepted norms of behavior. So how do you then stop them from being antisocial or digressing from their normal behavior? You can only take recourse to law, because law has both punishment and penalty, and people, to make them law abiding or to make them fall into place, you have to use punitive measures, and this is the role of law. Now, what is the Constitution? If we look at the larger context of Constitution, it is the basic structure. It is the document which contains the basic structure of governance and the political setup of a country. Now, simply speaking, you can say that Constitution is the foundational law of the country. It is the very basis on which the government agencies and other institutions are built. So what is the purpose of the Constitution? One of the purposes of the Constitution is to define clearly the powers of the center, if it is a federal government, to define clearly the powers of the center and the state government, so that there are no legal conflicts between the center and the state. It also then clearly separates the power and defines the domains of the three organs of the government. This is called horizontal separation of powers. So legislature, executive and judiciary, their roles have been clearly mentioned in the Constitution. Not only this, the Constitution also defines the domains of activity. What are the powers and what are the functions of the center, the state, the legislature, the judiciary and the executive. Apart from this, the Constitution has, the most important thing is that it binds the government also by the law. It says that the government only does not create laws or does not formulate laws, but it also has to put in certain clauses and committing itself to those laws. So this is important. And if we have to, if the other purpose is that the Constitution also lays down procedures for its own amendment, which is very important, because it is not only amendments which are important, but how to amend is also very important. So amendment procedures, because the founding fathers of our Constitution, the framers of the Constitution, they realized that a Constitution with changing times, in order to become more relevant, has to be changed time and again, and this procedure was called amendment. The clear procedure for amendments under Article 368 are laid down in the Constitution. So the Constitution is very progressive, because it doesn't only say this, do that, but it also says this is the way the Constitution itself needs to be changed. Now, law is an essential tool of government. In governance, when we talk about good governance or when we talk about governance, for example, one pillar of governance is law. And law is the means by which government itself is structured, regulated and controlled, because we cannot impose laws on the citizen unless the government itself is bound by certain laws. There are parameters drawn, there are framework or boundaries drawn, and the government cannot...
Sorry to interrupt, we have a call from Gujarat. Good afternoon, please ask your question.
गुड आफ्टरनून सर
जी, प्लीज आस्क योर क्वेश्चन.
इतना पूछना चाहता हूँ
जी
कि हमारी पॉलिटिक्स की डेफिनेशन क्या है. एक बात ये, मैंने तो इतना देखा, इतना समझा है, आज तक हमारा कॉन्स्टिट्यूशन को समझा है, देखा है, उसका अनुभव किया है. इसको कैसा अब बनाने की जरूरत है वो कहूँगा मैं. सबसे पहले तो पॉलिटिकल पार्टियां नहीं होनी चाहिए देश के अंदर. ये हमारी एकता और अखंडता के लिए सबसे बड़ा खतरा बन चुकी है आज की तारीख में, क्योंकि पब्लिक हमेशा इसके कारण डिवाइड रहते हैं, वो कभी एकता नहीं आती है.
आपका जो प्रश्न,
ये बिल्कुल आप सुनने जैसी बात है
जी,
बिल्कुल जरूरी भी है हमारे देश के लिए.
जी जी. ये आपका आपका प्रश्न हम लोग को समझ में आ गया। पॉलिटिक्स क्या है, इस पर जो डेमोक्रेटिक सेटअप में पॉलिटिक्स का क्या धारणा है, उस पर मैं रिक्वेस्ट करता हूँ मैडम बताएंगी पॉलिटिक्स का क्या डेमोक्रेटिक सेटअप में धारणा है।
Two aspects. If when we do political science, basically there are two aspects. One is the theoretical aspect, so that is political science. So this is a normative concept. This should be the ideal condition. A democracy must have multiplicity of parties. But what is actually happening in the society and what is the real politic is different, and that is politics. So the practical aspect of political science, the practical issues which come up in the day-to-day activities of the government is politics. Coming to your second part of the question, you say that we do not need political parties, but the very essence of democracy is one of the prerequisites of democracy is the existence of political parties, a large number of, so that we have ample choice. The moment we do away with political parties, we head towards one party democracy, which then is a kind of an authoritarian regime, and that is not democracy. So since India has adopted democracy, we need to have multiplicity of political parties. I hope I was able to satisfy you.
Okay, now we continue.
Now, coming back to the lecture, law shapes how politics is conducted. If the just I'm linking it to the question which came, that if the political parties were given free hand, they would take every regime change would have had n number of laws made, and those laws made to suit that particular party. But we have to bear in mind that it is not the political parties which are determining the making of law, it's also vice versa, that law is shaping how politics is to be conducted, that there are certain norms which political parties must follow, and you cannot make a U-turn in decision. Once, for every 5 years, if we had that kind, then the entire constitution would have thousands of amendments, and this is not possible. So law also shapes how politics is conducted. Now, role of law in politics, if we look at the international angle, now let us just move beyond national issues and to international angle. What is the role of lawyers, for example, in international relations? Now, international relations, if we cannot have non-technical, non-legal people going and representing states, because states, the theory of sovereignty, theory of legal sovereignty says that sovereignty is a legal concept where every state is equal to another state, irrespective of the size, irrespective of the number of people staying in that particular state. Therefore, now who best to represent the countries in international institutions or international bodies, or if there is a conflict, you have a mediation or arbitration tribunal set up, who should go and represent? So it is the lawyers who go and do it. Therefore, law becomes important. Then draw limits of territorial sovereignty. Not only this, law is important in determining the territorial boundaries, because in international politics we have n number of states, A, B, C, D, E, and the relationship between them is never cooperative. Most of the time it is conflicting relationship.
We have another call. Good afternoon, please ask your question. Okay, got disconnected.
Okay. So now this territorial sovereignty mostly has boundary disputes. You have border commissions or boundary commissions which are set up, and at least 50% of people on these commissions or committees are lawyers. Therefore, the role of lawyers becomes very important. Now, if a country was given free hand, it would go on increasing its power, because this is realism according to Hans Morgenthau, who says that international relations is all about acquisition of more and more power. So you have to put a halt to how many countries you can conquer or how much transgression you can do in another country. And who limits this? This is international law. Now, international law also, now there is a very important aspect. It ensures the lawyers, or the law ensures observance of pacts and treaties.
Okay. We have call from West Bengal. Good afternoon, friend. Please ask your question. Please ask your question.
There are many governments, state governments and national, they don't obey the orders of the court.
Okay.
So what are the provisions that the court can enforce its order?
Okay. both the state government and central government to obey the order of the court, but what is the provision that they, how they can enforce the orders?
Okay, there is no mechanism as such to enforce, but of course, with judicial activism, the judiciary has the right to ensure that its orders are obeyed. So it is a practical consideration that if the judiciary gives an order, it has to be obeyed. Otherwise, there can be issues of contempt.
So it means High Court only can instruct the government.
Instruct the government, and it can take action as contempt.
Okay.
At times, yes.
Okay, at times. In rare case.
Yeah.
Okay. So we have, I think, another question. Okay, continue.
Okay. The law ensures observance of pacts and treaties, and this in legal term is called pacto sunt servanda, means all the treaties and pacts that have been signed or agreed must be observed. And who ensures the observance? Because a country is very easily likely to digress and fall away, but it is international law which ensures that any country who has signed a treaty has to observe the terms and conditions of the treaties. Now, the other role of law in international relations is that when countries, they transact, they do business or they do political exchanges, there are major problems which arise, and this problem is mostly related to differences in the legal tradition of the different countries. For example, the law in India, labor law in India, will not be the same as the labor law in US. So you have to bring them to converge if they are doing some political and economic negotiations. And how
We have call from Uttar Pradesh. Good afternoon, friends. Please ask our question. जी सवाल पूछिए.
हेलो.
जी सवाल पूछिए.
What are the major functions of the National Human Rights?
Major function of
Human Rights Commission.
National
Oh,
Human Rights Commission?
Human Rights Commission here.
Yeah.
Major function of Human Rights Commission.
Okay. The national human rights, there are different kinds of rights that we have by birth, and these are called our natural rights. Some of these rights have been made fundamental rights. So the Constitution takes care of those fundamental rights. There are many more rights which may not be fundamental rights, but they are very necessary for the very existence of human life. These are called human rights. So for the protection of these human rights, and especially issues related to women or minority or the suppressed classes, we have an agency called the National Human Rights Commission, which takes up even litigations on behalf of those who have been denied certain human rights.
And it started with the UN Convention.
Yes.
19
UDHR, the
Okay.
Universal Declaration of Human Rights.
Okay.
Yes.
We have. Okay.
Okay.
Now we have only 1 minute, so you can
Okay.
sum up that.
Okay, I'll just sum up. Removing differences in legal tradition of different countries is another role of politics, role of law in politics. It also guides the formation of how IMF was to be formed or how World Bank was to be formed. All these were determined by the legal personnel. I'll just jump to judicial review. Judicial review is one aspect which is very important, and judicial review is very, very conflicting area because the judiciary is made supreme over the legislature, and this is one area of conflict which has always remained in India. And judicial review always is viewed as as a issue which has led to encroachment on the rights of legislature.
Okay.
So I'll just summarize that state is an organized society and laws are the rules which determine social conduct. Government is the group of individuals who see that laws are being enforced. Law sets procedural framework for political activity, and there is a two-way relationship from law to politics and politics to law, and in the end good governance means good laws.
Okay, so well friends, with this word we conclude the lecture. I thank all of you for watching the lecture, and on your behalf I thank Dr. Aparajita Kashyap for giving such a wonderful lecture. Thank you very much.